versus Paulo Webster. Appellant's counsel.
Good afternoon. May it please the court. My name is Kristen McGanna. I'm here on behalf of Southwest Airlines and their workers' compensation carrier, Sedgwick CMS. At this time, Your Honors, I would like to reserve 4 minutes for rebuttal.
Noted. Thank you.
Thank you. Your Honors, this case, we argue, represents a misapplication or overextension of the 120-day rule, which is outlined in 440204. Now, just generally, that rule provides the employer carrier with 3 options when they get a claim or notice of a condition. They can either accept the claim and pay, they can file a notice of denial, or they can pay and investigate for 120 days. In this case, Your Honor, the judge below found that by virtue of the employer carrier treating a compensable left leg injury over the course of several years, and then once it traveled or once it became apparent on the right leg, had not issued a denial before that time, but rather right after the right leg was assessed for treatment, that condition was accepted under the 120-day rule, and the employer carrier was obligated to pay ongoing treatment. Now, for purposes, the facts, Your Honor, as in regard to the claimant, Ms. Webster's treatment, are not entirely in dispute. Again, this is a 2011 date of accident. Ms. Webster was in the course of her employment when she suffered a traumatic injury to her left shin. That shin promptly resulted in a lesion, a wound in the left shin, and that, Your Honors, is what we argue was treated over the course of the next 12 to 13 years. Now, there's a lot of medical records and evidence that have been discussed.
What's the difference between hepatitis and PG?
Well, they're very different conditions, Your Honor. In this case, PG is somewhat unique because it manifests in different areas of the body, as we've learned in the case. Now, in this case, it did not arise until she suffered.
What's the body part involved in hepatitis?
Hepatitis C is a blood disorder, to my understanding. Obviously, I'm not a doctor, Your Honor, but it is my understanding this is a blood disorder. PG, pyodermic gangrenosum, is an autoimmune condition that often manifests in skin lesions. In this case, it happened to arise or manifested as a result of a traumatic injury to the left shin. I would argue, Your Honor, that if you look at the medical records, if you even look at the EMA, Dr. Seth Waxman's testimony, it was never really determined whether or not these lesions resulted as a result of the trauma to the left shin, or just appeared just as a matter of course. There was some explanation.
But he did acknowledge and say, within a reasonable degree of medical certainty, there was no pre-existing history, that this, following this accident and the cut to the shin and the wounds, that's when the PG was activated, or I think the term was incited, correct? That's
correct, Your Honor. And I think, respectfully, I think it was more that he couldn't rule out the trauma to the left shin as the preemptive cause. At this point, I agree, we don't have any record evidence of Ms. Webster having the history of the condition. I think she denies having the condition to this day, but that's, another matter. Really, when it occurred or when it was first noticed was afterwards as she was treating for the shin. Now, what's important for our purposes, Your Honor, is at all times, what was treated was the same area of the trauma to the body part, right? And so I think everyone acknowledges that for 13 years, what was treated was the left leg. Ms. Webster, adhering and at all times, has insisted that she had continuous symptoms to the left leg starting in 2011 up until even the time of the hearing last year in 2023.
I'm sorry, Chief.
I was just going to follow up. What makes this case different from Bynum if the hepatitis in that case, the PG in this case, were both I guess arguably in Bynum, were both precipitated with the injury?
Well, Your Honor, I don't think there was any discussion at that point that hepatitis was precipitated by the injury. In this case, we have him just happening to be diagnosed with hepatitis afterwards. And that's in Bynum, I mean. In our case, there's discussion throughout the medical records and ultimately by Dr. Seth Waxman, the EMA, that this trauma might very well have caused this PG to manifest. Now, our argument, in terms of why our case is distinguished from Bynum, is that in Bynum, it was a physical injury. It was a motor vehicle accident where he sustained physical injury. So the employer care started treating that. At the same time, they started treating hepatitis, which was a completely separate unrelated, obviously, blood disorder. And they continued to treat that until, obviously, after the 120 days, and then they denied it.
So the fact that the hepatitis could have been introduced, and I'm just reading from this, because he was lying with open wounds after the truck accident, that mud might have infected him with the hepatitis. That's sort of beside the point, or I shouldn't read anything into that.
Yeah, and I did see that, Your Honor, and obviously I agree that's what the case says, but I think in that case, there really wasn't any medical discussion about that. You know, here we have medical records that suggest this could have been caused by it, you know. I mean, I think there was just a question by the employer early on in Bynum. Here, I think we just had continuous symptoms at the same site involving where the traumatic injury occurred as where PG is. Now, in terms of kind of your point, Judge Tannenbaum, in terms of the difference is PG manifests itself separately throughout all areas of the body in sort of skin disorders, skin lesions.
I thought hepatitis in some way, I mean, literally, if you translate the Latin, involves the liver. Isn't that inflammation of the liver in some way? Is that what hepatitis is?
Yeah, Your Honor, I think it might be. I think that is one of the ways, you know, one of the damages it causes to the body is the liver. I mean, here though, why it's been, you know, treated, why we've continued to treat it, and why this has come up, because this injury resulted in a laceration to the shin. And she just started receiving wound care for that at all times. We would argue, Your Honor, that, you know, this condition she's had, if you look at the medical records, it's been caused several different things. Crush injury, abscess, lesions, cellulitis, hyperkeratosis, C. diff, osteomyelitis, and then, of course, pyoderma gangrenosum.
Well, let me ask you to clarify for me. The way the issue is framed in the briefs, and you've used the word previously, it's whether the JCC improperly extended the 120-day rule. Can you give me some clarification on what you mean by extended? Now, is that either, number one, that you're arguing that the 120-day rule ran from initial provision of benefits, or 120 ran from the immediate documented diagnosis of PG, or are you moving that or using the extension semantic to mean it's 120 days from when the right leg first appeared on a medical record? So can you make a distinction with that and tell me exactly what your argument is?
Yes, sure, Your Honor. It's probably the better phrase or term we're trying to argue is just a misapplication. We argue it should not have been applied in our scenario to basically make the PG compensable, because what we've been treating is the wound to the left leg. We argue it should not be applied for a new manifestation, a new arisal of symptoms related to this PG in a completely separate body part. That is essentially our argument. We're saying that the 120-day rule should not bar us from denying an entirely separate body part, a different manifestation of a condition, when we've been treating a wound in one.
So the manifestation of the right leg, that's what you're arguing, 120 shouldn't apply to the right leg?
That's correct.
All right, so a couple of questions. And looking back at the medical records, et cetera, you were paying for an authorized treating physician who gave some treatments for the neurogenic pain. I think there was a argument whether it was RSD. There's what I call the old, it's now changed.
Right.
The old RSD.
CRPS,
we used
correct.
to know, and neuropathic pain. But there were some injections provided, and I think there was even a spinal block provided that I assume treated both the left and the right leg. But this whole time, there's documented right leg, and there's treatment being provided. So from the time that the right leg appeared in medical records as what you indicate is a new symptom, how many days between that surfacing and when the first denial, whether it was in a response to petition or a filed denial, how much time elapsed before a response in some way from the employer carrier?
Well, Your Honor, I think, and I would acknowledge that the first denial was when there was a claim for treatment for the right leg, which was in 2022.
So the response to petition.
That's correct, Your Honor. Yes. I mean, we are arguing that, yes, there were treatments for pain throughout, because that's what she presented to the authorized doctors with, right? And that's a result of what we were treating as manifestations of this wound, this trauma to the left leg. Now that, again, manifested in nerve pain, mobility issues, again, the skin lesions, and that was what we were treating the entire time. Once there was a referral for the right leg, and as you pointed out, Your Honor, that was initially described by the pain management doctor as CRPS or RSD, whatever your preference is, that is when that was denied because the left leg, the left shin is what had been accepted as compensable, not another body part. And
So then the appellee is arguing, I guess, the point of dispute, one of the points of dispute here is the appellee claims that this autoimmune condition can count as a separate injury for purposes of determining compensability. And your position is, no, PG can't be a separate injury. It's a idiopathic or idiosyncratic response to an injury, and that there has to be a new body part involved before the issue of compensability comes up.
right,
again.
well, essentially, Your Honor,
the difference?
what the argument is and what the issue is, and I know my esteemed colleague is going to say that Bynum applies, and Bynum binds this court to finding that we treated PG, so no matter where it appears on the body, we've bought that condition, and
Right,
we
but
have to treat
I'm trying
it.
to understand under the concept of compensability and injury, even under like, how is it that a blood, let's just assume it is a blood condition as opposed to, I read it as hepatitis as a body part, you got the liver, that's your body part, and that's the distinction. But what is the statutory basis to treat any sort of idiopathic response to an injury as a separate injury?
Well, again, Your Honor, I think you just have to look at, and what this court has always said with the 120 day is, what has been accepted as compensable? What is the injury or what is the condition? I think, and our argument has always been that what was treated this whole time is what happened as a result of that trauma. Now, again, that could be, as you pointed out, Judge Thomas, as Dr. Waxman testified, a response to the trauma to the left leg. So we're arguing what was accepted was that trauma to the left leg. And again, that has manifested in different ways, including possibly PG. We argue, Your Honor, that is a limitation of what has been accepted as compensable. And so therefore, once there was a referral for treatment in a different body part, that was timely denied. There was never, we would argue, Your Honor, that no authorized treatment has provided for the right leg specifically.
But doesn't Bynum suggest that injuries can involve things other than body parts?
Your Honor, I think Bynum stands for the proposition that in that case, based on the facts presented, the employer carrier had accepted compensability of hepatitis C. And we're just
And what's
distinguishing.
the body part? That's when we get back to my original question. So what's the body part involved in hepatitis C? Is it the blood? And how specific does it have to be? So an autoimmune, so if you're talking about the white blood cells, is that considered to be a body part for purposes of injury?
Well, Your Honor, I think it's up to this court. And what the JCC below found was that it was the pyoderma gangrenosum as a whole that was compensable. And again, because of that, and because the EMA found that this is what was causing the issues in the right leg, that was their basis, or that was the judge's basis below for finding the physical therapy for the right leg, because that's what we're on, Your Honor, essentially right now, is Dr. Paterno, the pain management's, he diagnosed CRPS and found it had traveled to the right leg, and then therefore prescribed physical therapy. Again, that's the basis for the petition that, was presented to the judge and why we're here today. But the EMA got it based on, the authorized.
We've had a line of cases, and it's supported by statute, that pre-existing or idiopathic conditions completely unrelated to a comp accident can be covered as compensable if they inhibit the recovery of a compensable injury. So you could use, diabetes is the classic example, where many times in comp cases, the carrier treats and pays for diabetic treatment because it inhibits the recovery of directly compensable accidents. So how do you distinguish that line of thinking and with your argument here? And
Your Honor, I don't think we necessarily need to distinguish, because I think that, might very well help us, right? Because I don't think it would be possible, going back, the purpose of the Chapter 440, as this court even recognized last year in the Churchill decision, was to facilitate benefits to the injured worker without a lot of litigation, without us having to be here today, right? And And, you know, there was no time, I don't think we could have distinguished the two, this left leg and the PG, because it was all so intertwined. And I know that I'm probably borrowing language from another subject, but I just don't think we could have just been filing denials because at no time was there a break in this treatment, right?
Well, I think it kind of goes back to the policy behind 120-day rule and why you see 120-day in the most complex circumstances occur when there's some form of exposure element to it. For example, here, a hit on the shin that could have introduced infection, you know, exposure to chemicals, things like that. And because we have such a heightened exposure standard for claimants to show, and it's got to be timely notice if you have to do testing to show what those exposures are. You know, that's why the policy behind this 120 days to give an injured worker notice that you plan to pay or not pay, or you've got 120 days. I mean, doesn't your argument go against the policy for 120-day rule in terms of notice?
Well, again, Your Honor, we don't think that it should have been applied at all in this case, right? I mean, we treated this condition as dictated by the authorized doctors up until there was a referral for, we considered a new condition, right? We challenged the condition below that was initially CRPS or RSD, and the EMA agreed with us on that. But again, this turned into, well, this is the same condition, but it just appeared somewhere else, and that's when we challenged it. So this kind of goes back to our argument about how it was improperly applied or overextended, because again, we don't think it should have been applied to this case. And I'm getting into my rebuttal time, but just to be quick, Your Honors, as to point 3, that's again more of a alternate argument, because the basis for the therapy that the EMA ultimately found related to, quote, the PG was because of unauthorized treatment the claimant had unauthorized outside of workers' compensation. So we argue, Your Honor, that even assuming, and you know, we're requesting this court does not, find the PG compensable or affirm the JCC's findings below, that physical therapy, which is the only issue here today, should not have been authorized, because if you look at the EMA's reasoning for finding physical therapy reasonable medically necessary, it was based on the debridements and grafting the claimant had outside of workers' compensation. And again, we think that is a break in the causal chain. And with that, Your Honor, I'm getting into my rebuttal, but we are requesting that this court reverse the order below. Thank you.
Your Honors, may it please the Court, I'm Mark Tobey from Coral Gables for the appellee, Paola Webster. Ms. Webster, as you have noted, was injured while working for Southwest Airlines. She suffers now from pyoderma gangrenosum. We call it PG a lot because it's a lot of a mouthful. The judge found that this condition was diagnosed as early as 2012. It was in medical records. There's a specific medical record from the dermatologist indicating that it was discussed not only with the patient, but with the case manager. That's in the record on page 337. The judge specifically found PG to be in the records, and the judge specifically found that at no point within the 120 days following 2012 did the employer carrier deny the medical condition, deny that the treatment was needed, and they provided treatment. So continuing
to treatment for the injury, which is to the left shin?
Well, the injury to the left shin initiated this pyoderma gangrenosum
which complicated
response.
The healing, which then prompted need for additional medical care to help with the healing, right?
Correct. Much like hepatitis, it could have been caused by this injury, or it could have been caused by something else. And that would have been the time back in 2012 for the carrier to investigate that. That's what 44020 is about. When the 120-day rule was inserted into the statute in 1994, that was the same time that major contributing cause was introduced into the statute. This is the time limitation that the employer carrier has to investigate their obligation to provide benefits under 44013 on the medical, which in fact is where compensable is defined, is in 44013 1D. That's the definition. Compensable is not defined 440.02 as a general, it's under the medical portion. That was also added in 1994 at the same time that the 120-day rule was added. And
So whether it's PG or hepatitis C or diabetes, something that complicates healing of a workplace accident, you treat it without reservation, you own it forever. So in the diabetes case, you own the diabetes treatment, therefore in hepatitis, you own the hepatitis thereafter, PG, you own that from hereafter. Is that the argument?
well, you can own it. It depends upon what the employer carrier does in terms of investigating and taking action as the statute prescribes. If
Right, but
the,
assuming they don't, and they just pay it and don't do anything else, do they own it? Is their position that they own it going forward?
they,
That's what I heard the chief say.
they own it going forward. They own the condition.
How
They
do you
own
square
the-
that with Checkers then?
I'm sorry?
How do you square that with Checkers then?
Checkers is different. Checkers, well, first of all, in Checkers, the judge found that the claimant had recovered from the injury. But Checkers is about an aggravation. Checkers is about an exacerbation. It's not a similar type of situation here where this is it's an injury to a specific body part, but the reaction is differently. Like
Why is that not an exacerbation or an acceleration or?
because that's not the nature of the condition. And 440.13.2a says that the, subject to the limitations elsewhere, that the medically necessary remedial treatment, care, and attendance for such a period as the nature of the injury or the process of the recovery may require. So based on the nature of the injury, things are different.
Right, but that's the distinction, one of the distinctions that I thought that Checkers made, is that, yes, there can be entitlement to additional treatment based on the injury, you know, based on medical necessity and those kinds of things, but that's a different question than compensability.
Well,
So
the
the question
compensability,
is, are you arguing that the PG is a separate compensable injury, I guess?
yes, the PG was accepted as the compensable injury. Once it was diagnosed in 2012,
So all you need is a diagnosis. As long as there's a diagnosis in the record, that counts as a separate injury?
no, you need a diagnosis, you need the carrier to provide treatment, and you need the carrier not to deny treatment within 120 days,
Well, no,
as they
I'm
did in
asking about
Bynum.
when the 120-day rule kicks in, I'm asking for the purpose of identifying the injury that is compensable, that then prompts all the medical care, potentially indemnity, all these other things. How do you mark what the injuries are? I mean, you have the initial injury that's sometimes obvious, most of the time obvious. You may have subsequent injuries that people weren't initially aware of that then pop up, as long as it's resulting from the initial accident. It also is compensable. What's the difference between that and providing medical care for a variety of symptoms or manifestations, including, you know, an idiopathic response to an injury?
Well, the difference is the legislature understood that there needed to be time limitations for the carrier to investigate whether or not they had an obligation to provide care, and that's where the 120-day rule comes in.
I would distinguish Checkers myself as different from this type scenario where our line of cases and the statute, to me, say there's a difference in a pre-existing idiopathic condition that is accepted or treatment is authorized for after an on-the-job accident if that pre-existing unrelated condition inhibits the recovery of the compensable injuries. That's one set. That's a Checkers. Separate and distinct from a circumstance here where she didn't know she had this issue. The doctor said, it's an autoimmune issue. We don't know what causes it, but never had any problems with this before. The shin and the accident initiated or triggered or incited this condition to then, be inflamed or ignited in her body, et cetera, and so forth. So, a causal connection between perhaps a dormant condition that is incited by a compensable accident or not. I think that analysis is separate than a known pre-existing idiopathic condition that's simply treated for a finite period of time if it inhibits the recovery of compensable injuries. Would you agree with that or not?
I would agree with that. And in this situation, it comes to fruition because it would be illogical to believe that that initial bump on the shin is still the cause of what was being treated 12 years later. That wouldn't make sense. Something else must have happened. And you're right. The autoimmune was either caused by this or triggered by this. But this accident, this injury is what made it, this accident made it compensable, made it jump up, as the doctor indicated, and it could jump up anywhere in the body. It coincidentally jumped up at the site of this injury.
But that was true before the accident, too, right? This diagnosis is that this is an autoimmune, a pre-existing autoimmune issue that manifests itself or not on its own schedule. I guess what I'm having trouble with is, how does right leg link to the accident? Is there a link there?
The link is the condition, the nature of PG, and it isn't presumed that this was a pre-existing condition. It is understood that that was likely the situation, but as the judge pointed out in the record on page 34, as is the case here, it was observed that hepatitis C could have been caused by the work accident, but that was never proven. That's supported by the deposition testimony of the EMA, who indicated that the trauma is one of the things that can cause the pyoderma gangrenosum. So this accident may have been the cause of the autoimmune condition.
Is that significant? If this was a pre-existing condition, then your case loses, but if there's a potential cause, as in Bynum, a potential cause with the accident, then that gives the claim life.
No, it actually reiterates why the legislature put the 120-day rule into effect, which is because there need to be time limitations on these things. It's not right for the claimant to have to try and go back 13 years after an accident, 12 years after an accident, and try and prove that things are related. The employer carrier had to act within the time period that the legislature prescribed to understand their obligation as to what the nature is of what they were treating. They were treating the pyoderma gangrenosum.
In the left shin.
Well, they were treating it. They were treating the condition itself.
When it turned out that it was actually affecting the right leg as well, they denied authorization because and the EMA agreed that there's actually not a connection between the right leg and the original accident.
No, the EMA, the EMA said that there's no relation between the pyoderma gangrenosum and the industrial accident, maybe, or he said it could be the cause.
And that wasn't
what he said is we'll never know.
The JCC tended to agree as well. I mean, the JCC focused on, it's like that's all very interesting, but PG was already accepted as being compensable, so they lose.
Correct, because they had the opportunity to investigate it once it was diagnosed in 2012, and they continued to authorize care specifically for the pyoderma gangrenosum.
Is there any evidence in the record showing that the PG could have been like hepatitis, where there's a bacteria that would happen to be on the surface that she banged her shin on, and it was introduced from the outside into her bloodstream?
There is not, but had this case been denied originally, then perhaps that evidence might have been developed. But 12 years later, there wasn't going to be evidence to support that, and that's part of the reason that there's a 120-day rule, because once these conditions are made aware to the employer carrier, they have an obligation to investigate what is the limit to which they have to provide care. It's not for the claimant to have to reprove it. You all have said that.
Doesn't the claimant have to at least show what this thing is that you're relying on for the claim?
Well,
I mean, it doesn't seem to be a lot of answers to PG. It's a little like the complex pain syndrome thing. It's out there. It's the absence of any other explanation. It must be that. It sounds like with the PG, no one knows a whole lot about it. She's inflicted by it in some way. It's interfering with her ability to heal in her left shin. And now it's affecting her right leg. we don't know enough about it, so they lose because they were treating the complication in the left shin.
Well, they weren't treating a complication in the left shin, they were treating pyoderma gangrenosum. The EMA
At the
was,
site of the accident site.
I mean, yes, the left leg, I mean, the accident site could have been this big, it could have been this
And PG
big.
could have been cancer, could have been diabetes, could have been everything. And so once they're treating the accident site and it involves complications from, you name it, 100 other things, they own all those 100 other things they're going forward, is what I'm hearing.
But in this case, there is no other thing. There, if you look on page 337 of the record, it's the sole diagnosis that the dermatologist has. It's pyoderma gangrenosum. And then it says the presumed etiology, natural history, prognosis, and treatment options were discussed with patient and caseworker extensively. Appears clinically to be a lesion of pyoderma gangrenosum. Cannot state if this lesion is directly due to a work injury. I don't know what more they would need to be put on notice than that that's the only diagnosis that's involved. And from that point forward, they continued to treat the condition. The condition is pyoderma gangrenosum.
Can I ask you this question? In looking meticulously through all of the medical records and timelines, I see that we have the initiation, at least in medical notes, of right leg symptoms in March of 2019. That's when I start seeing right leg. And then we have a relocation to Texas and Paterno notes, there's both legs. The carrier then authorizes lumbar sympathetic nerve blocks, which seem to help both the right and the left legs, et cetera. And then we have a petition filed, which is the subject of this appeal, April 27th, 2022. So that's 2 to 3 years after the first time I see a right leg complaint. And then we have a response to petition saying we are not paying for anything for the left leg. So based on that timeline, is there an argument as far as you're concerned that even if you looked at this from 120 days being triggered by the first mention of right leg, separate and apart from whether it's PG or right or left leg, that the 120-day rule, if we applied it to when the right leg starts in March, they blew that one too?
Yes, and I have that on page, I believe, 24 of the record in the judge's order, where the judge found that there was treatment to the right leg. And the petition for benefits, treatment that, after the indication that there was problems with the right leg, as you indicated, the injections and such. And the treatment that was provided after that continued to be provided for the entire condition. The petition for benefits asks for the physical therapy for the left and the right leg, and the employer carrier agreed and provided the physical therapy for the left leg. They just denied the right leg. But before that, there was no provision of either of the therapies. So I don't know how you do gait and balance therapy without involving both legs. You need them both to walk. So that was part of what was being treated all along in terms of physical therapy.
Does your client have any obligation at any point to mention in the PFB that, or treat this as a compensability determination, or to ask for a compensability determination? As opposed to filing a PFB seeking authorization for therapy. When I look at the PFB, it does not appear that you are treating PG as if it's a separate injury. It looks like you're asking for additional treatment now for the right leg.
Well, because the injury has already been accepted as compensable by virtue of the fact that they're providing treatment for it, and it's the same condition. So nothing has changed. There's no reason to keep asking for compensability. You wouldn't ask in the hepatitis situation, if the person's suffering from jaundice, you wouldn't ask for a separate determination of compensability of the jaundice. That's part of the nature of the condition.
Because the body part, the liver, is already being affected, and jaundice is another manifestation of hepatitis.
And
my question here
lesions
is
and pain. I'm sorry?
What's the body part involved with the PG? Separate from the left shin.
Well, the left shin isn't the body part involved in the PG. The PG is an autoimmune condition, so it could be the white blood cells. It didn't really get developed, but the body part is not the relevant thing. I mean, hepatitis.
Can pain by itself be a separate compensable injury?
If objective, I don't know that it can be unless objective. There has to be objective medical evidence to support pain. Pain is typically considered a non-objective finding. There are some other studies, that pain can be something, I guess, a sensitization. I don't know the specifics. I think it could be under the right circumstances, but
I mean, the reason I ask is, so let's say, there's accepted compensability, an injury is accepted as being compensable. Let's say it's the left knee. And in the course of that, the claimant is experiencing some pain regarding the knee, maybe excruciating pain. And the employer authorizes, pain treatment or pain management for that related to the injury to the knee. Has the employer now accepted any sort of pain complex? The person is has some sort of idiopathic pain reaction. So it then later manifests itself on the right side of the body somewhere. Has the employer in that situation accepted compensability for the pain separate and apart from the left knee?
well, in your situation there, you said the left knee was injured, but you didn't put a specific injury involved. So there's no condition that you've identified that I can tell you whether or not that condition would be something that would happen in the right. RSD, which is now called CRPS, it can result from a crush trauma or surgery or casting, those types of things, and that pain can move along through the body to other parts.
But
so
is it a separate injury?
Is pain itself a separate injury?
Yeah.
If defined?
Like in your scenario?
Or is it a manifestation?
Yeah.
It would depend on the injury. Pain is typically a symptom of some other problem, but if there's a medical condition that could be objectively identified as pain, I don't see why. I have not run into that scenario in my practice, so I'm not sure where that's headed. But with regard to this, the PG was the accepted condition. The nature of the condition means that it isn't just limited to a specific body part. It can be found elsewhere. PTSD would be another one of those from the Sierra case. So there are conditions that are not specific to a body part, and even if they are specific to a body part, it doesn't mean that it can't cause problems elsewhere. And the nature of this condition is that it can cause problems in a number of different areas because of how it is. The judge of compensations claims understood that. She applied the 120-day rule appropriately, and we ask that you affirm her order.
So if the condition, just one more question, so if the condition was hemophilia, this left shin wouldn't clot, and that was addressed, initially and complicated the healing, what have you. A scratch on the arm 8 years later has hemophilia, you're saying, I understand your case to be hemophilia is now covered.
No, you would have presented a subsequent intervening accident which would break the chain of causation. That was the employer carrier's obligation in this case, was to do exactly what you just did, Your Honor.
But that's different from compensability, isn't it? I mean, the employer or the JCC looked at it, regardless of what the EMA said about the link between the accident and the PG and the right leg. The JCC went straight to the 120-day rule, and the fact that they didn't deny compensability within 120 days with respect to the PG means that they own the PG. So in this instance, what the chief just, the example that the chief just mentioned, not the question was, well, they were already treating the hemophilia, so they've already accepted the hemophilia as a separate injury.
But as in Checkers and the other line of cases, it doesn't prevent them from arguing that the major contributing cause of the specific treatment. Your scratch would require treatment because of a subsequent intervening accident, and they could still argue major contributing cause. They could have done that in this case, but there was no subsequent intervening accident. There was no additional thing. You're right. The hemophilia would be a compensable condition if they provided the treatment for it and they failed to deny it at any point after, or indicate that they were limiting their treatment to just what it needed to help in this situation. They would have bought it, but they wouldn't have bought that additional treatment for the scratch because they would have still had the major contributing cause defense available to them.
Would it help for a distinction if we had in the examples that the chief gave? So if that was a comp case, it would be, for example, diagnosis, right knee laceration, complicated by hemophilia. We're treating the hemophilia. Second scenario where you get a scratch on the shoulder, it would be an unrelated, non-work-related scratch that obviously is complicated by hemophilia, but your diagnosis is the key there, where your argument is in this case the diagnosis has been for 3 years PG. It wasn't shin laceration, complicated by pre-existing PG. It has been a consistent years-long diagnosis of PG.
Yes, Your Honor, that's what they were treating.
But then, using the chief's example one more time, let's say there isn't a separate scratch to the arm. There's been treatment for hemophilia because of, I forget what the original injury was, but whatever the original thing was, that the hemophilia made it difficult to treat or cure. Over a number of years, the employer continues to treat that injury that's been complicated by the hemophilia, and then at some point along the line, the claimant or the employee says, hey, I now have this other problem. Let's say it's showing up now in my right leg because of the hemophilia. Or
bloody
something like
nose.
that. Or a bloody
Secondary
nose,
bloody nose.
without an accident, just it starts happening. Can the employer, maybe they're not successful, but can't the employer at least take the position that there's not a link between the accident and whatever's going on with the bloody nose? It may have been caused by hemophilia, but there's some break in the chain.
They certainly have defenses available to them if there was a break in the chain.
Isn't that what they're arguing here? What's the difference between the two?
Well, the difference is, like Sierra, you can't use the original condition and say that that's the break in the chain. There has to be something else. You can't just go back and say, well, it's no longer PG. I mean, it's still PG. There's no way to undo the PG. So you can't go back and say, well, now that the PG's more of a problem, we don't want to do it. There has to be a time limitation, which is what the 120-day rule does, is it limits the time, which I am way over on
Thank you.
mine.
Yeah, we need a time limitation here too. Thank you very much.
Thank you.
Collins Counsel, and let's add 5 minutes to her.
Okay. Thank you, Your Honors. May it please the Court, starting sort of with the last points you were making in terms of the break at the causal chain, again, that sort of goes to what I was rushing through in my last couple minutes of my main argument. Here, we had an alternative argument that there was a break in the causal chain for the recommendation of physical therapy because the EMA, when he did recommend that as a result of the pyoderma gangrenosum, testified specifically when asked, is the therapy necessary? He said, I think if you're going to have skin grafting and you're going to be deconditioned from that, PT is going to be required. Even if she wasn't in the work comp system, she would probably require PT. So he was relating, again, the mobility issue she was having on the right non-accepted leg to pyoderma gangrenosum by virtue of treatment she had outside of the workers' comp system. So that's the break in the causal chain we are arguing. Now, sort of going back to the general premise behind the 120-day rule, Your Honors, I think what drives it, what prompts it, is notice to the employer. Here, what notice was given to the employer? She had an injury to the left leg. They began treating it. They treated it uninterruptedly. Yes, there were complications of PG associated with that in the left leg. They did continue to treat it. I'm not sure why now we're in a situation where suddenly we have to start filing a lot of denials when, again, the purpose behind Chapter 440 is to facilitate benefits to the injured worker, which was what was done here. I don't think it's necessarily fair to impose this notice for any other body part ever. Again, what is being treated is trauma to the left leg, and we would argue that to the extent compensability is an issue, it should be limited to that. Once you get to the right leg, we would argue that goes beyond what notice was provided to the employer in terms of the nature of PG and where else it might occur in the body. And similar to your discussion about hemophilia, Your Honor, I think I argued below, and again in my brief, it's similar to a skin cancer or any type of cancer. You know, we know that cancer is a disease process of the body, but if, and I know there are cases, especially in the first responder system, you know, if there's an acceptance of skin cancer at some point, are we then obligated to accept every form of cancer, or is it evaluated distinctly? And I think here, I would argue it should be evaluated distinctly. I don't think us treating a condition in a specific body part that was involved in the initial injury should mean that we're liable for every body part no matter what, when, in this case, it was presented or addressed by the EMA, it can be prompted by trauma. So I think there should be some allowance of the employer to evaluate if we have separate skin conditions. But again,
What
Your
about,
Honor.
what about what Judge Thomas was asking about before? Wasn't the employer on notice in some way about the right leg earlier on because of what's in the medical records?
Yeah, and I think that goes, Your Honor, to your questions about pain. You know, is pain a compensable injury? Yes, she talked about pain, I think, but if you look at the adjuster's testimony, it's been consistently, we only authorize the doctors to treat the left leg. I don't think there's any express authorization of the doctor to treat anything other than the affected left leg. No authorization was extended to treat the right leg. I mean, you know, a patient can go to a doctor and complain about any number of things, right? But what you need to look at is what actually was treated. And we argue that up until there was a referral for physical therapy of both legs, that was the first time treatment was specifically recommended for the right leg, and at that point, that was denied. Again, the basis was CRPS, but then it turned into PG, but again, we argue that to the extent there's a compensability issue, it should be limited to the affected left leg. And, Your Honor, I don't think I have anything else to add unless there are other questions. Thank you, Your Honors. Again, we're asking for reversal. Appreciate your time today.
Thank you, counsel. We're adjourned.
All right.